Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are talking about a company that was incorporated in 2010. And shortly after its incorporation, we have two parties. One of them is the plaintiff and one of them is the first defendant. And shortly after the incorporation, we've got the plaintiff and first defendant, who are siblings. They are the 50-50 shareholders. They each own half the shares, and they are the only two directors of the company. So the two siblings are in control. Now, this company was incorporated shortly after the plaintiff and the first defendant entered into an agreement between themselves whereby they were going to contribute 50-50 to purchase a property. They were going to take 50% of the proceeds of rent in respect to the property, and they were going to be recorded 50-50 owners in respect of that property. What we actually have is this company that they've incorporated together buys the property and becomes the registered proprietor of it after that agreement being made. Does that make sense? I hope it does, but essentially one way to think about it is that company is the vehicle on the plaintiff's view of the world for that agreement being upheld. Now, the property had a tenant, and the tenant was itself a company, and that company was wholly controlled by the first defendant's spouse. We flash ahead to 2012, and by this stage the plaintiff retires as director, and the plaintiff says that they can't recall whether or not they actually did that or whether the first defendant just lodged the form with the ASIC. But by the time we get to 2012, we've got the company who owns the property, we've got the company that is a tenant, and that company being controlled by the first defendant's spouse, and we've got the plaintiff sort of low on visibility and either having been forced to retire or actually retiring as a director. Now, we flash forward to 2021, and there is a terse exchange between the plaintiff and the first defendant about the nature of what's going on with the property, and there is a sort of veiled, slightly unclear threat allegedly made by the first defendant to transfer out some of the assets of the company. What actually ends up happening is that ownership of the property is transferred out of the hands of the company and into the hands of another company under the control of defendant one and their spouse. And what is recorded on the real estate transfer in respect of that sale is that the value of that transfer was $0. So we run through that again. We've got the property leaving the company's hands and going in the hands of another entity under the control of the first defendant and the first defendant's spouse for $0 according to the paper records. Now, at around this time, we have a message coming from the first defendant to the plaintiff to say, hey look, we've secured a sale at 1.7 million. The net outcome of that to you, net of tax and that sort of thing, is that I'm going to make a payment to you of about 700, and there's about 24 grand in back rent, so you'll get your 724 soon, and we'll deal with some of the tax consequences down the road. We'll see how it all nets out in the end. And this payment is in fact made. A little while after this, the company is deregistered by the first defendant without the plaintiff's knowledge or approval. Now, another little fact to jam in between those two things is that at or around the time ownership of the property is transferred, defendant one emails to the plaintiff a valuation of the property that suggests the value of it might be about 2.4, 2.5. And immediately after that, sends one of those email recall attempts to recall that email back, right? So the 2.4, 2.5 val's been sent, an attempt to claw it back. Short minutes after that, a valuation that looks very similar comes through, but at 1.7 to 2.0. And so we have this set of facts confronting the position. And don't forget that the defendant went on to deregister the company. Now, what we are dealing with today is the plaintiff coming to the court to apply to seek to re-register, to bring back from the dead this deregistered company in order to examine and pursue some claims that the plaintiff thinks they have. And so that is pursuant to section 601 cap A cap H of the Corporations Act, and that is the section that the plaintiff is relying on. The plaintiff is coming to the court to say, hey, can we get this company out of the grave? Can we get it back on its feet, living dead style, in order for me to bring some of these claims? The types of claims that the plaintiff is thinking of bringing are either an oppression claim, that's a claim that like a shareholder or a similar sort of person has been unfairly prejudiced by the way a company's run, or a derivative action claim, where a shareholder sort of tries to stand in the shoes of a company and sue someone on behalf of the company, right? So I think you can get the feel for what the plaintiff's after, saying all these weird transactions, they were either oppressive to me, unfairly prejudicial to me, or they are claims the company has against defendant one to get that money back, probably alleging a breach of director's duties or something like that. Now, crucially, the plaintiff also puts before the court evidence of rent not paid. And the plaintiff does their sums and says, look, I reckon there's about 1.6 million in rent from 2010, the time the company purchased the property, to 2024, the time the hearing's going on. And I've seen about 94 grand of that. And so there's this open question of like, where's all this rent gone as well? So the court, remember, the court's not finally determining the dispute. The court's just saying, are we bringing this company back from the dead? Now, one of the reasons the court might bring the company back from the dead is if an aggrieved person has a claim. And so the court considers the claim and looks at the relevant principles. And importantly, for this re-registration sort of application, you don't have to prove, oh, your claim is the greatest and best in the world, and for the court to really closely forensically examine it. The court merely needs to see there's an arguable claim, and the court notes the principle that essentially there's a low threshold. The court here looks at the evidence and finds that low threshold has been met and says, yep, that's enough for us. We're going to re-register the company. Now, what happens when the company's re-registered is the people who were directors at the time of deregistration jump straight back into the driver's seat when the company comes back from the dead. And so no one really wants that director back in charge. The director themselves consents to all these orders being made and consents to immediately retiring at the time the company comes back from the dead. The plaintiff and the plaintiff's nephew are then installed as directors, or they agree to be installed as directors. Everyone agrees to that course, and they're the next steps. So the orders that are made include re-registration, noting that defendant one is going to retire. And there's an interesting order about costs. Right? Often we talk about costs following the event when we're talking about litigation. And what we mean when we say that is, if you win, you get reimbursed for a significant amount of your legal costs. Now here, what the court said was, the costs of this argument, this 601H re-registration argument, are going to be reserved, and they will become costs in the cause in relation to the oppression proceedings or the derivative action proceedings. Does that make sense? So this isn't treated as a one-off piece of litigation. This is treated more as a preliminary piece lining up to what the plaintiff might have in mind for the next steps in the litigation. So a little bit fiddly, a little bit procedural, but I hope that discussion assisted you, and I look forward to joining you again soon over another coffee and in respect of another case note. Cheers.